Namaskar. Welcome to my channel Journey of Constitution of India. On 6th August 2019, Indian Parliament passed the landmark Consumer Protection Bill 2019, which aims to provide the timely and effective administration of justice and settlement of consumer disputes. Just after 3 days, on 9th August 2019, the Consumer Protection Act 2019 received the assent of President of India and was published in the official gazette. On 16th July 2020, the notification of the central government came that the 2019 Act will be in force from tomorrow, that is 20th of July 2020. So after 34 years, we got this new act replacing the Consumer Protection Act of 1986. 34 years is a pretty long period, and and particularly in this age of super fast computer and super fast internet, and that technology is shaping and redefining every aspect of the interaction of people. So this 34 years is a very sufficient period, and now the new act is to meet the new challenges and new age consumer expectations. Do you think provisions like e-commerce and the increase of pecuniary jurisdiction of the district commission and state commission are going to end the sufferings of the consumers? Let us see how effectively it is going to work for the benefit of the consumers. What I feel that much needs to be done in the front of infrastructure development and creating the proper cadre of judicial and non-judicial member of the consumer commissions. Just think of 118 posts of the president and 362 posts of the members are lying vacant in 596 districts all over India. So if almost one third of the consumer commissions are working without president and almost 40-45% are working without their members of the commission. So what do you think? How capable are these consumer courts to dispense with the duty cast upon them by the new act to provide the time-bound justice? Friends, during this lockdown, we interacted frequently on the different topics, and you supported me by subscribing my channel as well as giving your comments on and your opinions to me, and that has significantly improved my contents and the contents of the video and my presentation. So I'm very thankful to you. Thank you very much. Please wish me good luck by subscribing my channel Journey of Constitution of India. The first important thing I find in the new act of 2019 is the change in the jurisdiction, pecuniary as well as the territory. For the first time, territory jurisdiction has been enhanced by incorporating the provision that even the complaint can be filed at the place where the complainant is residing. This will facilitate a lot to the consumers, and their sufferings will be reduced significantly. This is a very significant change from my point of view. And then the other change is the pecuniary jurisdiction of the consumer district forum, which is now known as the district commission, and it has been increased from up to 1 crore rupees, and the state commission jurisdiction is from 1 crore to 10 crore rupees, and after 10 crore it is the national commission. So this is a very welcome move in the present scenario, and this will facilitate a lot to the consumer. Now, if you ask me what is one path breaking provisions incorporated in the new act, then I will say, of course, it is the establishment of a new regulatory with the name Central Consumer Protection Authority. This has been given wide power of investigation, search and seizure, and there will be an independent investigating agency with this authority, and that will be headed by a director general. This will have independent power to inquiry and investigate, and in case of violation of consumer rights and unfair trade practices for class actions. The organization, if works well, can prove wonder in the field of consumer justice, and it is going to redefine the entire consumer safety. So let us see to what extent this new created organization is going to work and facilitate the process of consumer justice administration. The next thing, if you ask me, what is one brilliant new idea incorporated in this new act, then I'll say the concept of product liability. Product liability is the new concept. It has been defined in its definition section, and within its fold, it is not just the product manufacturer, but also the product service providers are also brought within the purview of the products seller, and as well as the grounds of defectiveness of goods and services that has caused harm to a person or his property on the grounds. Earlier, if the consumer wanted damages, then he or she has to approach the civil court, because the damages were taken as something civil court can better decide. But with bringing this concept in the Consumer Act, the consumer commission will be very much capable of giving the damages and the losses caused. So next is, what is one unique and good new age concept? New age concept I am particularly saying, then this is the concept of unfair contract. Unfair contract has broadened the concept of the consumer dispute, and the consumers are no more no more taken left and right by the service provider or product or the manufacturer by making the consumer to sign on the dotted lines and making unconscionable agreement bereft of fairness. So if an agreement is found to be unfair to the consumers, then that may be declared by the consumer commission unfair contract. So this is a very unique concept, and this is in tune with the international concept, a unique provision to safeguard the consumer interest against the unfair contract by declaring that contract illegal. An unfair contract is, if a contract is unreasonable, unfair, derogatory to the interest of consumer, such as reserving right of unilateral termination of the agreement, or reserving the right, or assigning without any assignment or without consent, imposing any unilateral penalty or breach of any breach which is disproportionate to the loss caused to the manufacturer or the person who signed the contract. So this unfair contract has broadened the concept of consumer loss. Now the next is, what steps has been taken to safeguard the data of public, because in this new age of digital concept and digitalization of the every services, and so a new concept has been derived. New safeguard was required to safeguard the personal data of the consumers. So in this context, sharing of personal data collected from the consumer by any person will be considered as the unfair trade practices, and he will be penalized as per law if the data is shared without the consent of the consumers. Next, even a very good concept has been incorporated here, that penalties for misleading advertisement and safeguard is provided even to the celebrities who are endorsing this. This is the first time it is provided, that it provides that if a false description and guarantee of product or service is found prejudicial to the interest of the consumers, then penalty up to rupees or 10 lakhs may be imposed. If found guilty, it may be sentenced for up to 2 years. So this is something giving very hard, very strict provisions, and a teeth is given to the consumer commissions providing consumer justice. The other concept which here it is, I would like to mention that the celebrity endorsement. Earlier, the celebrity used to endorse the product or services, and if anything happened, they were not found anything responsible for, accountable for it. But now this concept has been introduced in the new law, where the endorsers has to take the onus and exercise due diligence to verify the veracity of the claims made in the advertisement, and to refute liability claims. Otherwise, a penalty up to rupees 10 lakhs may be imposed, or ban for 1 year extendable to the 3 years may be imposed on the person who is endorsing, and particularly the celebrity who are endorsing any product. The other thing which I would like to say, there is one provision which is inserted here, which is the need of hour, and this is bringing the e-commerce transactions within the fold, and online transactions, electronic means, tele-shopping, direct shopping, or multi-level marketing. These all concepts are brought within the purview of the consumer disputes, and if anything happens on this front, they will be taken to task. There are some very good procedural change also incorporated in the new act, like the complaint can be filed by electronic media. E-filing has been introduced, and this will reduce um, the hardships of to the consumer to a very significant level. Even hearing or examining parties through video conferencing has been incorporated. So this is incorporated with having eye on the future. This is something of future oriented, and this will facilitate the entire process very to a great extent. The other important change which has been brought and which has been institutionalized by incorporating the provision in the new act, that is the provision of mediation, because now mediation is in the statute, and even it starts from the pre-trial stage. After the complaint is filed and it is admitted, the other parties is given notice. When he comes to, if on writing they give to the court within 5 days, then it will be sent to the mediation. So this mediation will help to a great extent to reduce even the burden on the court. Now, provision of this alternate dispute mechanism and resolution process is very welcome steps. The only concern is now the creating proper infrastructure. No doubt, this new act covers almost all aspects of difficulties which were being faced by consumers as well as the consumer commissions. So, but for proper implementation of this act, we need proper infrastructure and a a congenial working ethos, working sentiments, and working process in the court, so that the consumer can feel comfortable approaching there for the redressal of their problems. And the other thing which I personally feel, that there should be a separate cadre of the judicial and non-judicial member who are working in the consumer courts, so that these posts should not lie vacant for years and years, which is the great cause of hardship for the consumers. And even let me tell you, almost 450,000 cases are pending in the consumer courts, which are lying there for many years. And ultimately, justice delayed is justice denied, and particularly in the concept in the field of consumer jurisprudence, so much delay is not tolerable. Let us conclude this journey by saying that gone are the days when the caveat emptor or beware buyers was the main ideas. Now this is the service provider or the product or the manufacturer has to be aware. Now consumer is king and seller has to beware. With this, we conclude this journey. Thank you very much for watching this video, and we will make another video with further detail giving you about the section wise changes made in this. And if you find this video worth, then please share it with your friends. And secondly, that please share your ideas so that we can improve the contents and presentation of the video. Thank you very much. Wish me good luck by subscribing my channel. Namaskar.